Thank you so much for watching Law School Made Easy at Law School Made Easy 256. Today, we want to look at the contract questions. We want to discuss one question from contract law, and the question goes that in contract law, not all agreements are contracts discussed. In contract law, not all agreements are contracts discussed. So one thing I want to tell the first year students is whenever you meet a question, whether you need a paper or the 8 questions, whichever questions you read, first think about the topics you covered in that semester, such that you place the topics. For example, we know that this semester you have looked at offer, we have looked at acceptance, considerations, intention to create legal bounds, capacity, contents of an agreement, of a contract, uh, some areas, agency. Now, when you meet such a question that in contract law, not all agreements are contracts discussed, first thing you comes to your mind, think about which topic are they picking this from? Which topic are they picking this question from? What does this question want? Let those topics be running in your head. Before I even discuss this question for you, I can give you a second. You guess before I enter which question, which topic is this question in contract law. Not all agreements are contracts discussed. Now, whichever you have said, my opinion is this question is in intention to create legal bounds. They are saying that not all agreements are contract. That in your day-to-day, as we begin to dissect, let's first interpret the question, that people enter into many agreements. You may agree with the boyfriend that we shall meet for a cup of tea in the evening. If the boyfriend doesn't show up, you dress and you go to Java's, you go to Sheraton, and your boyfriend doesn't show up, was there intention to create legal bounds? Is that a contract? Can you successfully sue in the courts of law because your boyfriend didn't show up? So that is the question. They are saying that not all agreements are contracts, meaning there are agreements which are contracts. So this one takes us to two things. This question is two-sided. You can even use your senior 6 history that questions which I've discussed at the end are two-sided in most cases. So this question is requiring you to show us agreements which are not contracts, and then also agreements which are contracts. But the first thing you do when you meet such a question is for you to identify the keywords. In this case, the keywords in here are in contract law. So we are in contract. So the first thing you do is to define for us what is a contract. And I'm saying, do not define what a contract is because you got an A in English. You are now showing us how you know a lot of English. You begin to bring your English. This is law. Tell us that Section 2 of the Contracts Act defines or provides a contract to mean an agreement enforceable by law. Forget about your English. We have a constitutional provision. We have an act provision in the Contracts Act. Tell us, what does contract mean in Section 2? Remember, most of the Section 2s in all acts, most of them, they have definitions of different terminologies you are going to use in that act. Now the contract is defined in section 2. But there is an expansion in section 10 that clearly provides a contract to mean that an agreement entered in with free consent, with capacity to contract, lawful consideration, with a lawful object, and intention to create legal bounds. Now, you must define what a contract is. You don't stop there. We have locus classicus cases that defines what a contract is. For example, you go ahead and say, in Kasozi, William Kasozi versus DFCU, it defined the elements that make a valid contract, and then you outline the principle in William Kasozi's case versus DFCU, how they were laid down. And then now you go into the gist of the matter. It has no harm if you begin by telling your examiner that not all arguments are contracts. However, not all that you intend to discuss the point that not all arguments are contracts. And then you now take us to tell us they are social or domestic agreements, that most of the social or domestic agreements are not contracts. But because most of them, there is no intention to create legal bounds. For example, contracts of married people, husband and wife. Then you give us a case of Balfour versus Balfour. And you explain the principle in Balfour that because the woman was sick and the man promised to give her some upkeep, which she did fulfill, and the woman was now suing. The woman was now suing for damages, and the court held that the man, there was no intention to create legal bounds. It was only a promise made to a wife that I would pay you this amount. So you discuss the principles in Balfour versus Balfour. And maybe to bring it to your attention, where you see cases of Balfour versus Balfour, let's say Thomas versus Thomas in consideration, normally those are husband and wife. They're normally, you will see them in family law, more in family law, that merit, petite versus petite, those are normally husband and wife when they have a conflict. Now, you now clearly say that the concept in Balfour, much as it was harsh to the married people, but there was no intention to create legal bounds. The husband, Balfour, would not be held accountable for whatever that had happened. Then, another case which really shows that not all arguments are arguments is petite. I implore everybody to look at petite. But then, there are social agreements or domestic agreements that can be contracts. For example, in merit versus merit, I want us to discuss merit. In merit versus merit, the husband, merit and merit, they had a mortgage house, call it loan house, and of course they separated. But the husband promised the woman, they met in the husband's car, and the husband told the woman, you clear up this. When you clear up, I will sign the transfer, I think, of the house to you. And so what the woman did, the woman asked him to sign somewhere, was still in the car. So the man signed, and the woman cleared the debt, and on telling him to now fulfill his promise, he refused. So on going to court held that much as it was a special case, much as it was, because the man wanted to rely on the case of Balfour versus Balfour, where a man was, in Balfour, a man was exonerated. Now here, he wanted to rely on it, but court were very clear that in this case, the idea of writing, remember what you put in writing, you can only remove it by writing. So because there was some writings, then a woman was awarded damages. The man lost the case because he wrote. So the writing meant that we intend to create legal bounds. So that is an agreement, that is a contract. So you can go ahead. I implore everybody to read the case of Jones versus Padabaton. And then you continue to read that not all agreements are contracts. Now, you now switch to the other side, and then you discuss commercial agreements. That most of the commercial agreements are all contracts. That agreements made in commercial transactions, that all those are contracts. But you can rebut them on the presumption that you put an implied term in the contract. If there is an implied term in that contract, then it is possible that you can revert, that you can rebut it. But where there is no implied term in the contract, then all commercial agreements are considered to be agreements. You can look at the case of Edward versus Skyways. He was a pilot who had a contract, and they laid him off. They asked him to resign by writing a letter. But in their agreements made earlier, he was entitled to, whether they send him away, he was entitled to pension, ex gratia. So he accepted the resignation, and in their contract, it was that if he resigns, they forced him to resign, he would be paid up everything, all his money, salaries. So he accepted to resign, and he was paid off. Edwards was paid off all the monies. Now, little did they know that they were also supposed to pay him the pension. So they were arguing that since we have paid him this money, we cannot pay him. They said, no. It is clear that he is entitled to the pension, and the pension was now given to him. The Skyways lost the case. So we are saying that commercial contracts are all agreements. There are those cases, Venom versus Pool Table, I think, versus Venom case, and very many others. So we are saying that commercial agreements are all contracts, except to where there are implied terms or put in the contract that suggests, that negates that in case of anything, this contract will go to the negative side. We can take a vivid example. If we sign a contract with someone to do something for us, but we put a clause in that contract saying that you will not be getting this amount if you do ABCD, and then they accept and sign the contract. The moment they do not do anything, they want to go against the contract, then this clause will help you to run away from the contract. But other than that, all contracts which are commercial all agreements which are commercial are all contracts. So that is how we go about this question. And now after, you can conclude by saying that most of social and domestic contracts are not contracts, but all commercial agreements are contracts where there are no implied terms that are put in the in that contract. So that is how you go about the question. In contract law, not all agreements are contracts. So we want to thank you so much for watching Law School Made Easy at Law School Made Easy 256. We ask you to subscribe, to share, and like our videos. Thank you so much.